Here we are, back again with our last video of the year. So, as I brought up in our last video, this one's going to be the differences between civil and criminal court, but more specifically with the procedural aspect of it. So, as always, the joke of the day. So, today's joke is, what does a lawyer wear to court? A lawsuit. So, I'm sorry. That's the best I could come up with. I know it's terrible, but as always, take a few minutes, laugh it off, and now we get back to POD. So, the criminal court case, as you're going to see, is similar in some aspects with the actual court process. But the pretrial part is going to be just vastly, it's going to be a big difference. So to get to it, the first thing for a criminal court procedure is going to be an arrest. And again, civil court, you're trying to sue somebody for damages. You're trying to get a monetary value out of it. In criminal court, the government is going to be trying to charge an individual with breaking a law, something with the penal code of the state, and there is going to potentially be jail time. So the first thing that happens with this is going to be an arrest. So you are arrested, you are read your rights, and then you are placed in prison. Now, what they can do to create this arrest, they can either witness you committing a crime, they can have a witness suspecting that person of committing a crime, a judge can issue an arrest warrant. All those things we've talked about before, but just know the first step is going to be the arrest. After that, you get to the booking process. Now, what happens here, police are going to fingerprint and photograph the suspect, just like you've seen in a lot of other court cases. Pretty standard procedure. They want to make sure that they have evidence of who you are. They want to make sure that your fingerprint isn't going to match up with somebody else's fingerprint, or another crime that may have been committed with the same fingerprint. But that's going to be the first step. After that, you are allowed to call a lawyer. If you can't afford a lawyer, one is going to be provided for you. But like I said in class, it's going to be a pretty low threshold to be able to have that court-provided attorney. But you want to make sure that you are well represented and you are legally represented with somebody who studies law for a living, not just listens to their POD teacher making videos. All right, and then after the booking process, a few hours, what's going to happen next? The suspect is going to be informed of their charges. Now, this is going to be known as your writ of habeas corpus. It's something that is guaranteed in the Constitution. Congress cannot suspend this right, but they want to make sure that you are going to be informed of your charges. The prosecution must show probable cause for believing the crime you committed it, but essentially just making sure that they have enough proof for this case to continue, because people aren't just going to be put in jail and them saying, well, we'll find evidence 2 months later. There's a system that needs to take place. Now, once the prosecution shows that probable cause, the judge is either going to send the accused back to jail, they're going to set bail, or release the accused. Now, if they don't have enough evidence, then they are going to be released. If they think that they have enough evidence, they are either going to send you back to jail or set bail. Now, bail, what that refers to is it's a guarantee that you make that you are going to come back when it is your time for court. Now, not everybody is going to be given bail. If they think that you committed a murder, they are not going to grant you bail because they see you as a threat to society. Or if you are what they call a flight risk. Essentially, what that means is they think that you are going to potentially leave because you know you're guilty and you're going to flee the country so you don't get to go back to prison. That's going to be the next step. After that, you get to the trial procedure. So the defense lawyer, they're going to interview witnesses, study law affecting the case, gather as much information as possible, just like you have in a civil case. So you're going to be getting ready essentially in the same way. The defendant, the person that is going to be accused of the crime, they have a right to a jury trial, or he may choose a bench trial. And really what the difference is on that, the jury is going to be a jury of your own peers. Sorry, my dog is hitting the computer. Either a jury of your own peers or a bench trial where just the judge is going to be the one deciding. So it's going to be up to the defendant to figure out which one that they want to have. And then if it is going to be a jury trial, then the selection of potential jurors is going to be starting up. And that process, it's kind of, it's random. They give them a list of say 50 people who they think are going to be jurors, and they try to figure out everything about that person to try to figure out if I would vote guilty or innocent. They also can kick people off the jury right away because they think that they are going to be biased. But that's going to be the selection of potential jurors. And then what happens then when the case is going to continue? You have your opening statements. So this is going to be something that you're going to be doing in your project. The opening statement is you are going to pretty much outline the case, why you think the person is innocent, why you think the person is guilty, and then give rationale for that reason. And then the prosecution and the defense, they are going to present their cases. They're going to call up witnesses who are going to give testimonies. And then once the prosecution side is done questioning their witness, then the defense gets to go and question the witness. So that's going to be called a cross-examination. So both sides are going to have the ability and the capability to be able to ask a witness any question that they want. While that's done, you then have a closing statement, which is going to highlight the testimony, again, explaining why you think the person is going to be innocent, why you think they're going to be guilty. A lot of times you wait to do this, you wait to write your closing statement until the end, because you want to see the jurors, see what their reaction is going to be to some of the different cases, or the different evidence that's going to be shown. And then the judge is going to explain the law to the jury. What they're going to be doing, trying to determine if a person is innocent or guilty, and explaining what they could be potentially guilty of. Now, reaching a verdict, what's going to happen here is the jury chooses a foreperson to lead the discussion. So the jury, they get to go back into what they call their chambers, which essentially is like, if you've ever been to the conference room in the high school, it's pretty much like that. You go there, there's a bunch of chairs, there's usually like bottles of water, and you get to sit down and you get to just basically discuss the case. You review evidence, you review the arguments. The judge determines whether or not you can take notes if you want to. But you basically just sit down, talk about what may have happened, and try to figure out what the case is going to be. They deliberate, they do this in secret. There isn't a time limit. They don't say you have a half hour. And then at the end of it, you vote whether the defendant is guilty or not guilty. And then to reach a guilty verdict, evidence must be convincing beyond what is known as a reasonable doubt. So if you're going to send somebody to prison for 60 years, I like that you need to have beyond a reasonable doubt to know that, yes, this person is the person that committed a murder. This is the person that did not pay taxes for 30 years or something along those lines. Because it is a pretty harsh punishment, having to go to prison. So they want to make sure that you have that beyond a reasonable doubt. In most instances, the verdict must be unanimous, meaning that if there's 9 people on the serving on the jury, they have to all 9 say that yes, the person is guilty. So a couple of other phrases that you're going to be seeing if you ever are in a court procedural case, hopefully in jury duty, which I know I always want jury duty, but I've never actually got to. But you get acquittal, which is the person is not guilty. Then you have what's called a hung jury. So a hung jury is that they cannot agree on a verdict. So there you have it. Those are the steps in a criminal case.